Governor.
Thank you very much, Chair. On the 2 dates mentioned, the last date, Chair, I had traveled. Then I'd indicated that I requested for a scheduling of the meeting. I was out of the country for that week, and then I saw the summons, Chair. But that notwithstanding, I'm happy to be here today. It was a prior scheduled visit that I couldn't move. That's why I appealed for the indulgence of the committee. On that date, I think it was the 8th of April. And I think the early one was the 14th of March, Chair.
So, Clerk, the summons, I think we must add a third demand, because you've demanded appearance in person, you've demanded written responses. We must also demand a written explanation for the non-appearance, including evidence of travel or evidence of commitment, because sometimes governors might just choose not to appear before the committee. So going forward, whenever we issue summons for non-appearance, that evidence must be put before the committee in writing, including any travel documents or travel-related documentation. Honorable members, the Powers and Privileges Act says where a person summoned does not appear, or where a person summoned appears and does not satisfy the committee may impose upon the person such a fine, and it's prescribed in the Parliamentary Powers and Privileges Act. Is there any member who is dissatisfied with the explanation by the governor? Should we consider the fines that are provided for in the Parliamentary Powers and Privileges Act? Senator Onyonka?
Chair, my opinion is that if the governor is able to present documents showing that he traveled and all that, I think then we can do a review.
Senator Mofaya?
Chair, I think His Excellency Governor Sakaja has been a member of Parliament for quite some time, and is very thorough on some issues. I don't know whether his absence or failure to appear before the committee was deliberate. So I think I agree with his presentation that he might have traveled, but of course I didn't go through your ruling that he has to prevent that's evidence that he was out of the country. So I think we should give him some benefit of doubt for that matter.
Senator Cherarkei?
I think, Chair, the essence on powers and privileges is, and even the principles of natural justice, is there should be compelling reasons. And I hope the governor will provide us with the traveling documents, which I think should not be a problem, as to why he did not appear. Of course, as a ranking member of Parliament who has been there for some time, I don't think he takes Parliament in vain. He must take Parliament seriously. And I want to believe, because he was my chair in Labour and Social Services, he used to teach me that Parliament must be respected. So I think, Chair, there should be compelling reasons, the provision of traveling documents, Chair, and any other documentation. And then from there, the ruling can be made. And like in the other county the other day, if there are no compelling reasons, then we go for full force of the law. But if there are compelling reasons, then it can mitigate the consequence and applications of powers and privileges. I thank you, Chair.
Senator Methu?
Chair, I know we are really pressed of time.
And remember, I'd asked for comments on those who are not satisfied with the governor's explanation. Proceed, Senator Methu.
Not necessarily not being satisfied, but I wanted to mention that and Governor Sakaja has been a member of Parliament. He knows that Parliament operates on its procedures and precedents. And the governor has said that he traveled. Last week, Honorable Chair, we were seized with the matter of a governor who had traveled. And from what we gathered, his reasons of travel were actually very compelling, because he had gone to pray. He had gone to Mecca to pray, if I actually remember very well. So I thought those reasons were compelling, but they didn't satisfy this committee that he should have left such an important legislative business of coming to appear before the Senate to go and pray. We actually fined that man. We told him that he should have prayed here, appeared before the Senate, and we move on. So Governor Sakaja has not even told us why he had traveled. At least that governor told us why he had traveled. He had traveled for prayers.
Is it your proposal that we impose the fine provided for in the Parliamentary Powers and Privileges Act?
It is a precedent that has been said already by this committee.
Okay. Maybe to avoid a debate on it, remember you must be referring to the Isiolo case. When the clerk read out the chronology of events, it turned out that there were 5 invitations that had not been honored in a span of 1 year. I think in the case of Governor Sakaja, it was 1 invitation. So that perhaps might make a distinction between the two.
So in that case, then I drop my proposal of finding him.
Okay.
The other one had even gone ahead and disparaged the committee, but Senator Sakaja has never.
Senator Mariam Omar?
Chair, me, I have a different opinion, because when you write, when we wrote someone, it means that we are not satisfied with this response, that he has not attended. And today, when he comes, there is no evidence that there is not a travel to wherever he's traveled. So I have different opportunity, different opinion, and also to make Senate to be having at least a teeth to bite with someone. Because when we write a someone letter, I don't think we have to debate on that. We totally go on someone issues. Sure.
Thank you, Senator Mariam Omar. Senator Sifuna?
Yeah, before Senator Sifuna,
Senator Dulo.
the statements made by Senator Methu should be expunged from this Hansard, because we didn't find, or rather we didn't even tell Governor for Isiolo, you should not have traveled to Mecca, you should have prayed there. That statement never actually, we never presented that statement. So I think...
Chair, on point of order, Senator Dulo is out of order. You cannot gag. The freedom of opinion and expression is in the Constitution.
No, I'm on a point of order. How can you...
Okay.
Fine, members, let's, I believe we are probably saying the same things, and I agree with Senator Dulo that those reasons alluded to by Senator Methu were not tabled.
No.
And that's why I have said that in our summons, we must demand.
But Mr. Chairman Garau said that it was not tabled. The letter that was written to this committee by the county secretary said that the governor had traveled to Mecca for pilgrimage. That is on record.
But
Unfortunately, unfortunately not. So, members, just to ensure that our proceedings are orderly, going forward, we have already directed the clerk that where a summon is issued to compel appearance, then the summoned officer or the summoned governor must in writing state the reasons for an appearance and provide evidence of other commitments for the consideration of the committee, so that it is not an oral presentation that then generates debate. Senator Sifuna.
Chair, for me, my concern is that we are running out of time. As we were briefed during the meeting with the Auditor General, we have 55 unresolved issues, Governor, in the financial year ending June 2022 alone. So we'll abide the decision of the committee and beg that we move to discuss the more substantive report in detail.
Honorable members, having listened to your submissions, I think there have been a mixed opinion, which is perfectly in order, because a committee that does not have differing opinions is like a committee of sheep, and we are not a committee of sheep. But having weighed the responses, under the circumstances, Governor Sakaja, within this committee, I'm not talking about the totality of the Senate, in this committee, in this case, he was a first offender. I'm not talking about the Energy Committee, I'm not talking about those other manenos, but within this committee, this summons, the governor was a first offender, and I will therefore direct that we proceed with the meeting.
Yeah, Chair, if you allow me.
Governor?
If you allow me just
and
briefly.
Be careful not to reopen a Pandora's box.
No, I don't want to open any box. Chair, as Senator Cherargei alluded, I have been a ranking member of the Senate and the National Assembly. And I want to give assurance to the committee that I understand and respect the place of the Senate. As you've given a comparison, mine was a summon after 1 invite. Others are 5 missed invites. This is my 13th appearance before the Senate committees. On Friday, I was with Senator Onyonka and another committee. So let senators be assured that I do respect the place and the role of the Senate for oversight. I had no reason not to want to come, especially given the fact that the financial years we're looking at, years where I was here with you in the Senate, they're not my time in office. That notwithstanding, government continues in perpetuity, and Chair, I'll always be available for the Senate. I think there's a perception that was created that I have a problem coming to Senate. Chair, I love coming to Senate. In fact, over the past few days, I've been here a lot looking at the improvement works I've done around here. And I hope I'm the first one to use this committee room as in terms of governance. So please have that assurance that the reason why we've been able even to catch up to this financial year. I've come here on audit for 2017-18, 18-19, 19-20. We're now looking at 2021 and 21-22. Means I've come even more times than my predecessors combined, you know. And so I'm happy that even after today, we should be able now to be on time with us. Even at the assembly, I've made sure my officers have been there. They've discussed 18-19, 19-20, and 20-21. And so that is the disposition that we have in Nairobi County. So please have that assurance, Chair, from Nairobi County and for myself.
Okay, that's important for the record, and it's also important for the House to allay that impression of non-cooperation. Members, I want us to go to the work
because you have said this for the record. Just 1 second, Honorable Chair.
Senator Methu.
For the 2 times that I have invited, because I'm also a chair of a committee, for the 2 times that I have invited the governor for Nairobi on matters to deal with Nairobi Water and Sanitation Company, he has appeared. So I confirm that what he has said is actually true.
I recall in the last parliament, the now governor for Makueni, Senator Mutula Kilonzo Jr., said we should be very worried when governors come before our committees happily. Let us proceed. Let us proceed. We shall proceed as follows. We've got 3 reports before us. We have spent time with the Auditor General looking at the issues that have been resolved and issues that are outstanding. Unfortunately, probably 95% of the issues raised by the Auditor General are still outstanding. We have taken time to go through the receipt of revenue statement, and we have taken the decision that we shall not prosecute the receipt of revenue statements today, because it has been brought to our attention that there is an ongoing inquiry in the County Assembly on the issue of systems and on-source revenue. And I think it would make sense for the Senate to allow the County Assembly to conclude that process and for the Senate to be informed by the report of the County Assembly. Because receipt of revenue is not just about bookkeeping and IPSAS compliance. We must also look at the environment. We must look at the systems, we must look at the processes, and we must look at the procedures. So we'll stand down the receiver of revenue report today. Secondly, we have looked at the expenditure report, and there is a huge issue around pending bills, close to 100 billion Kenya shillings. The bulk of the pending bills relate to legal fees and statutory deductions, particularly pensions benefits. The committee has also taken the position that we shall first consider the reports of the various task forces established by Nairobi City County to help us understand the background and get a better picture on those accounts payables. But with respect to legal fees, the committee has resolved that we shall engage experts to help us review the contingent liabilities, especially the issues that have been flagged by the Office of the Auditor General, so that, again, it is not just a conversation around debit and credit, but it is a conversation that covers lawfulness and prudence of some of those accounts payables. So ROR, we differ, and the conversation on legal fees and account payables relating to statutory deductions, we will have a specific meeting to address that. Because we... Yes. Governor, the task force, you established various task forces to look into pending bills. Maybe you could just let us know what those task forces were, because my intention is at the end of it, we must direct that we share with the Senate copies of those reports. Without even going into the details of the reports, just tell us you set up this task force, they've reported, the reports are available, and then we can agree on when those reports can be presented to the Senate.
Thank you very much, Chair. Chairman, as you rightly put, when we got into office in August 2022, we found a huge pending bill in Nairobi. The outstanding liabilities were close to 100 billion. And out of that, 21 billion was legal fees owing to different lawyers. Others were decretable amounts, and others were ongoing cases. Chair, because of that, 21 billion is higher than the equitable share that Nairobi receives in a year. That is twice the on-source revenue. And many of them seemed, suspicious. And so I set up a task force to look into the pending, the outstanding liabilities in the office of the county attorney. It was headed by Kamodho Iganjo. I brought in different professions in that task force. It wasn't just lawyers. Of course, there was the president of the LSK then as a member of the task force.
We had
Senator Cherokee?
Well, I appreciate, Chair, I don't know, because when you look at constitutional petition E003 of 2023 at Kitale High Court, it ruled that the formation of verification pending bills committee should not be done by counties, and it was declared unconstitutional. It should be exclusive domain of the Office of the Auditor General. So, Chair, while Governor is doing a lot in informing the committee what he has done, I don't know the implication of such ruling to what the Governor has already been informed, because the reading of this petition, and even Professor Nixon's also ruling, casts a shadow on the formation of verification committees. Because if it is unconstitutional now, where does it leave us? Because we might also be treading on because we are also the quasi-judicial process. So I don't know, with that declaration of unconstitutional formation of verification committees by governors, I don't know where does it leave us, because as far as I know, in this petition E003 of 2023, constitutional petition, there is no indication that one has been appealed. So I don't know where it leaves us or the implication. Maybe that clarification.
Senator Sifuna?
Chair, I would really have a wish that Senator Cherargei allows the governor to complete that statement. Just allow the governor to complete the statement, then we will bring in those questions.
Even though Senator Cherargei has a valid point, because a presentation has been made before this committee by the legal department on the implications of that ruling. And if you recall, Vice Chair, the judge did not entirely throw out the work that had been done by task forces. There was a rider that the Auditor General, the Auditor General needs to be involved in validation. But going forward, I think there was what do you do with the task forces already established, and how do you proceed going forward? So there was that distinction. So maybe when the governor completes his analogy, we will now establish whether he's been setting up task forces after that ruling. I believe that these were done before that ruling was rendered.
Yes.
But if we are wrong, you can correct us.
Thank you for your guidance, Chair. So I was explaining, when you find this huge pending bill, I set up this team, and I didn't want it just to be people of one profession, especially the legal profession, because that is what we were looking at with respect to the lawyers here. And so we had a few lawyers in that task force. We had supply chain management expert, one Mwenze. We had accountants, public finance experts from PKF, that is David Kabeberi. We had a tax master. And so the task force started their work, and they were reviewing They were able to give us a preliminary report. But in the middle of that work is when the ruling, that's why I'm grateful my senator has asked that I conclude, that ruling came out, which more or less outlawed these task forces, saying that they usurp the power of the Auditor General. Of course, as Nairobi, we don't agree with that, and we've been exploring how to, because these task forces help us make administrative decisions. It is not an audit, a financial audit, like what the Auditor General would do. In fact, from the 21 billion, so far they had actually come to how it can be reduced to 10 billion. They had given us advice on how to restructure the office of the county attorney, just like the state law office. Just based on that preliminary, report, I was able to engage the SRC to allow us to retain advocates in-house who would reduce our reliance with external advocates. If you look at the bill of 21 billion, if the SRC allows us to have, 6 years post-admission, pay them 250,000 or so, then many of the things that don't need to go to court will not go to court. And so we're currently in the process of recruiting around 50 counsel to be in different sectors. Most of our matters are land issues, disputes that don't need to make it there. Having said that, when that process stopped, we asked our internal team, led by the Office of the County Attorney, to review files. They looked at, as of last week, 144 files that they've been able to look at. The initial 44, for instance, because earlier, the decision on how much should be charged was a very subjective decision made by an individual. But we've seen that when it's a team, for instance, the reduction from 5.6 billion to 2.4, I think, Solicitor General, County Solicitor, 2.4 billion, for instance, and they're still ongoing. Last week they were in Naivasha, just focusing on that. And so we'll continue with the internal process, but so that, and if you look at that ruling, so that we don't waste taxpayers' money, the task forces need to conclude what they did. Now the legal quagmire we'll have is then, will the outcome of that task force be recognizable based on that ruling? And that's the advice we shall be seeking from the Senate. What we want really is to have some order and control with these liabilities from lawyers, And I would want, I'd urge even my senator to guide. If you look at some of the amounts charged, for instance, you have one advocate charging the county more than 10% of its own source revenue. I can give an example of a case if you allow me to. Somebody took us to court, took an MS and the county to court on the renovations at Uhuru Park, that were being done. That advocate then, who represented the county, charged the county 1.3 or so billion based on the value of Uhuru Park, as if Uhuru Park was being sold or was going. And you see, or another matter where there's a dispute between two, in an estate, a county estate, of an increase in rent. The entire quantum of that is 30,000 shillings, but the advocate charges you 60 million, shillings. So we'd really want advice on how to do it, because I've been very hesitant to settle such fees. But that's the process. I've only set up one task force. That's the only one that we'd set up. The county had earlier set up one under PLO Lumumba. That was during the time of Governor Mike Sonko, that looked at the outstanding liabilities. That task force, the report was being utilized during that time. When we got in, instead of putting everything in the task forces, every sector had to take or to validate the outstanding liabilities through internal audit. So the internal auditor, the chief officer, had to say, yes, this is what, and sign off. Now, when you ask them to sign off, automatically it reduces, incidentally. So through that process, again, from the office of the internal auditor, there was a reduction in those outstanding liabilities. But by head of that.
We said we will not get into the details, because my question is, what can the Senate consume at the moment out of those task forces? Is there a report that can be laid before the Senate that can guide us in considering the matters that are before us?
Yes, the earlier report was concluded. That was a PLO report from 2017. That one is available to be tabled.
The Kamotho Waiganjo report?
That one was not concluded. That's the one which we have a preliminary report, which we can still share. And that's the matter which we want to see whether do we appeal it, the ruling from Trans Nzoia. That's the one which only reached preliminary. There's no final report on the
Yeah, let's not mix up the two issues, because we are clear that as a governor, nothing stops you from having some people advising you.
Yes.
So if the task forces are advisory, I think that is within the law. But if it's in competition with the mandate of the OAG, that's a completely different matter. So what are you able to table before the Senate?
As of now, Chair, I'm able to table the preliminary report of the Kamodo Ganzo Task Force as we engage them to conclude. So we had paused that process.
You can present that to the Senate within the next 7 days?
Yes, sir. Yes, I can. Within the next 7 minutes, even, I can present that.
Let's make it 7 days to be orderly, but if you can do it in 7 minutes, the better,
Yeah.
so that members that can guide us in our conversation and in our approach towards the pending bills on legal fees.
Yes, Chair. And also, Chair, if you allow me to take this opportunity to correct a misconception. I saw, and I'm happy our friends from the Fourth Estate are here. Of course, we don't take that as sort of admissible in the House. That what was flagged was how 11 lawyers are owed 10 billion. But what was reported is that 11 lawyers were paid 10 billion. That is impossible, Chair. We would not be able to pay salaries. You know, that is our entire own source revenue. In that financial year, for instance, we only paid 287 million shillings. So thank you for allowing me the opportunity to just to clarify that. But I'm sure when you get to that financial year, we can go to the details of this payment.
Senator Sifuna?
Governor, is it your position that a lawyer cannot rack up 1 billion in bills? Especially where there's... just a minute.
Yeah.
Because in your annexures, you'll find there are certain law firms, and we will get into the details, certain law firms that appear to have preference in terms of getting jobs from the county government. And if you add the multiplicity of the suits that they've represented, it is possible for amounts to reach that high.
Yes, but not on a single matter.
Yes.
You know, when it's one matter, and if you look at the value for money to Wananchi, possibly a matter that didn't even need to go to court, there was no loss on the county. For instance, the case I've given of Uhuru Park, you know, paying that person 1.5 billion, which is even more than the amount it takes us to feed children for a whole year. You know, it might be right legally, but morally, you know, there's a conflict. That is why I would want advice, you know, to pay one person.
I think the point is we are dealing with a profession that is regulated.
Yeah.
We've got the remuneration, advocates remuneration order and the laws that relate to that. So we need to be careful in the statements that we make, because they must be within the law. But of course, the role of this committee is about prudence and responsibility.
Yes.
Those are the principles of public finance, and it's a constitutional principle, prudence and responsibility in utilization of public resources. So we need to ask ourselves whether the rules of certain professions introduce imprudence and irresponsibility in resource utilization. But members, since we have said we are going to have a separate hearing, maybe we can limit our contributions towards just the generalities rather than the details.
Chair, you know, I have to disclose that I am a former council member of the Law Society of Kenya. And whereas we agree that there are matters that are just manifestly, questionable and they should be looked into, there's also been this blanket condemnation of lawyers doing business with the county. You will find in most of these cases, there are letters of instruction, Governor, that originate from the county. There's correspondence between the government and those lawyers. There is even agreements on fees between the county government and some of these lawyers. Some of these matters have actually been taxed before the taxing masters in court, and with the rider that was given by Senator Omtata during the briefing, that if a taxation has resulted from a proper taxation and it was not a consent entered into between officials of your government and the lawyer, then really we should not demonize everybody. Because I also would agree that I cannot pay 1 billion shillings for a matter such as the one that you've raised of Uhuru Park. But I am hoping that those task forces have done the job of isolating the matters where an advocate was properly instructed. They did the job, because they're also very honest young lawyers trying to make a living in this city, and we shouldn't lump them together. And if it has gone through the process of taxation, Governor, and it's a proper taxation, not one that ended up with a consent order, then really those monies are payable. And it doesn't matter how long we run away from them, they should be paid.
Just hold on, Governor. Senator Onyonka.
Thank you, Chair.
Then Senator Cherargei.
Governor, I'm going to ask you just one question, and then the information I got is that Kisii County, before we had a task force which had been raised, which had been put together by the governor. In fact, there had been, and I want to raise up the bell on AOG, that actually on most of these pending bills, the OAG had already issued a report in most of the counties. What happened to that report? And the second issue, this comes to the question that Honorable my Secretary General has talked about, SG. This same committee sat here and we had a bill of 946 million from Machakos County for 4 years ago. I still haven't got an explanation how Machakos County got into a pending bill with the lawyers. And these lawyers actually were only 2 firms. I'm yet to get an explanation. So even when we are not passing aspersions on the legal fraternity, but the truth is most of these con jobs have been with the legal fraternity. I mean, let's just accept it. That's the way it is. So I need an explanation before we can even raise issues with the governor, because all these quirky deals have been done before even he came to office, but I know he needs to be answerable to that. At the same time, I would love to see what the Auditor General actually gave in terms of the reports and the audit you gave on most of these. Are we together? Yes, pending bills that need to be paid to the legal firms, because I know that Honorable Sifuna may not raise this issue, but Honorable Sifuna, I can tell you truthfully, I know friends of mine who've siphoned off 800 million from City Hall and they laugh at us.
Okay, let's not mix issues. And as you reflect also on, I think, must have been Kilifi and the element of internal collusion. Senator Cherargei.
Maybe to Governor, I was worried when I saw that there were some lawyers who are being owed by the county such amount. And it is good you have put on record, because I saw something on Twitter sometimes back, or X Corporation. But it seems you have legal counsel or a county solicitor and county attorney. Governor, I don't know whether county has contested those legal fees. Because as your senator has indicated rightfully, the taxation, taxing master and what have you, so to allay fears, and by the way, the country should know that lawyers can be owed $1 billion, because it depends with the value of what they are doing, and they are being guided by advocation remuneration order, which is regulated. But my only concern in prudent use as a county, have you gone ahead and maybe contested through the legal process, maybe moving to court, and your county solicitor and county attorney is here? Have you put in any measures to ensure it is being reviewed downwards so that it does not appear? By the way, Chair, it is not an offense that lawyers are being owed such huge colossal amount. But have you in the process contested or raised within the legal framework that is provided for the review of such amount, that so that you protect also the resources?
Okay, I'll take the governor's very brief response so that we don't get into the substance when you have said that we will have a special hearing on that. I think the governor is to provide us with the preliminary report, then we can take a view. But Governor, I'll allow you just a minute to respond to the concerns of the senators.
Thank you, Chair. And I'm happy the committee shares in our concerns because of the issue of prudence, on how we use these resources. Chair, I don't agree with blanket condemnation of the legal fraternity. In fact, the legal fraternity has really been helpful, for us to exercise our mandate and to deliver to the people. But there are certain cases, and the report, I'm just going through some of the interim recommendations. It highlights certain cases that are really just outliers, and those cases are really not acceptable. Yeah. And that is why in that task force I had the LSK represented, and the president of the LSK was there. In fact, even as if we refresh that team, the current president should take that position. I think the position is not an individual, but represent the fraternity. So the interest of lawyers is also looked at. there are so many cases, if you look at it, Chair, even if there's agreement from the county, sometimes some of them look like collusion, that take us to court on this matter and then we shall represent ourselves like this. Or if somebody is saying the bill is 1.5 billion and the county says, no, that is too much, reduce it to 1.45, you've done nothing, And so, in fact, at some point, I would really want this investigated, because these legal payments were used for a long time to just, bankrupt many counties and to siphon a lot of money. Many we have contested, Senator Cherargei, and we've been awarded costs actually on many matters. Some of the lawyers have helped us save our land that was, that has been taken. If you look at like the Kamudi issue, some of these lawyers have helped us, restore public assets. We've been able to recover so much based on them, but there must be some objectivity. And then how is it sustainable then going forward? In as much as, yes, you have an advocate's remuneration order and those, provisions of the law, we can enter into service level agreements, with some of these lawyers. We can put them on retainers. Some of them, we can have them tied in different clusters based on expertise and the subject matter. Because you will never see a private sector company, whether it is EABL or Safaricom, being charged certain fees because they have entered into certain service level agreements, which is what we want to move to. So, Chair, I'll be very happy when we have that discussion for us to say what improvements then we're making in the Office of the County Attorney, what proposals we have. When I asked SRC, for instance, to allow me to pay advocates a certain amount, they asked for the justification. And the justification was the pending bill, 21 billion. By increasing the salary of a few people, we can, avoid that kind of exposure. And moving forward, how do we strengthen counties, law offices? How do we have, even when they come in as interns or as, what do you call it, when you're at the School of Law, as pupils, and have pupil masters at the county to help us? We've realized a lot of our issues can be solved by arbitration, that they don't even need to go to court. But when they go to court, the amounts that we are charged, the example I gave you is actually a court case, Nairobi Beach Club versus NCC, for instance, Chair. The problem was that the rent for the restaurant went from 20,000 to 60,000. The tenant sued NCC. NCC instructed a lawyer. The fee note of the lawyer is 105 million because of an increase of rent of 40,000. Chair, it is not a conveyancing. The restaurant is not being sold. So such cases are so many, and that is why they need to be looked at so that we can be prudent. Even if we must pay lawyers.
Thank you, Governor. I think that members, we have agreed we'll have a special session on this. I think let's just close it by saying that we, as a Senate, we cannot override other laws that have already been established. The acts of parliament that govern remuneration of advocates, the Senate cannot rewrite it. The interest of the Senate would be to ensure that there's no collusion to defeat justice. The interest of the Senate would also be to ensure that the county is not losing due to inaction. And we have seen that the biggest component or a big component of those legal fees is interest, avoidable interest. And the interest of the Senate will be to ensure that there is prudence and responsibility. And that is why the County Attorneys Act was passed. And I think when we have that other conversation, we'll be asking for you to demonstrate to what extent you have complied with the requirements of the County Attorneys Act and whether that is bringing about the much needed reforms and savings for Nairobi City County.